Good afternoon, everyone. I'm Judge Corey Amanda Cawthon. We're here for the afternoon session of first appearances. I'll be going through our afternoon first appearance docket first, and then we'll be addressing the hearing docket afterward. Just a reminder to everyone that everything that we say is being recorded, so I encourage you to speak with your attorney before speaking on the record this afternoon. First, if I have him present, there is family signed in on Ryan John Ward, who is on page 4. Ma'am, let me see if they have him at the main jail. Hi, Mr. Romero. Okay, all right, thank you. Ma'am, you don't have to speak, or are you just here to observe? Just come to that podium right there. All right, so for the record, Mr. Ward, good afternoon. You're here on one count of criminal mischief. I find probable cause. And ma'am, how are you related to Mr. Ward?
I'm his mother, Mary Ward.
Okay, so are you here to just observe to see what happens today, or is there something that you want to say?
Well, I'm here on his behalf, and I don't know how this works, and
Okay. Okay, I'm gonna
take him if I can.
Okay, so here's what I'm gonna tell you. If there is anything that you want to tell me, then I'm gonna place you under oath and then let you say whatever you want. But I always tell everyone, everything that we say is being recorded and can be used later on, so that's always a warning. The other thing is, if you don't want to say anything, you don't have to. What will happen is, I will listen to the attorneys from the state attorney's office and the public defender's office, and then at the end of listening to what they have to tell me, I'll decide what his bond and release conditions are going to be. Okay? So does that make sense?
Yes.
Okay, so is there something that you want to tell me? Just tell me yes or no.
Yes.
Okay, so will you raise your right hand, please? Do you swear or affirm to tell the truth? Okay, and will you just state your name and spell your last name for the record?
It's Mary Ward, W-A-R-D.
Okay, thank you, Ms. Ward. So what do you want to tell us?
I just want to say my son's never been in trouble, and he's a good kid.
Okay, let me hear from the attorneys, and then we'll see what's going to happen here with Mr. Ward.
Judge, my understanding, Ward has very, very limited contact with the criminal justice system. Maybe I believe maybe a disorderly conduct or a public intoxication, something minor. Judge, he's been here his whole life. He's 28 years old. He works. He lives with his mother. He lives in Margate. Judge, he's going to be coming back to court. This is a misdemeanor offense. I'm asking if the court would consider an ROR on Mr. Ward's behalf.
I really see no history, Your Honor. I'm asking that the court order no victim contact.
So based on the fact that Mr. Ward doesn't have any history that's been presented, I will ROR him today. There will also be a no victim contact order. So Mr. Ward, a couple of things that you need to know. Number one, I don't know if you know the person whose vehicle this belongs to or anything, but whether you know them or not, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes.
Okay, the other thing that I want you to understand is that even though you're going to be released today, that does not necessarily mean that it is the end of the case. So it will be your responsibility to keep in contact with your attorneys and the clerk's office to know any future court dates that you need to be present for. Do you understand that?
Yes, I do.
Okay, all right, thank you very much. So Mom will be released later today. It might take a little bit for them to process him, okay? I'm sorry?
I leave now.
So you can leave now, and can she just go over to the jail? Okay, I know it takes some time for them to do it, okay?
Okay, so after 6 you're thinking? And then how do I know? Is he allowed to call to say that he's out, or?
I don't know if he has a cell phone or anything on him.
He should, whether
Okay,
it's...
so Mr. Romero, I don't know if he's still there with you. If he has a phone, make sure he calls his mom later, please.
Oh, he will. He
Okay,
will.
all right.
When he gets out, which is probably going to be 6 to 8 hours, I also believe there's a phone in reception. He can contact his mom, tell him to pick him up.
Okay,
Thank you.
all right. Thanks, Mom. Okay, next up is Jandra Parker.
She's approaching Judge here at me. Come on up, Ms. Parker.
Thank you. Good afternoon, Ms. Parker. Ms. Parker, you're before the court this afternoon on a misdemeanor capias. This comes from a charge for trespassing. I find probable cause. I'll hear from the parties.
Judge, she's homeless, she's financially indigent, she's not gonna be able to afford to post that monetary bond. And Judge, also,
She looking to,
I kind of have concerns, she might be a candidate for Judge Lerner.
Any objection from the state? All right. Then what I will do is, just as a matter of caution, I'm going to leave the bond in place and I will sign an order transferring her to Judge Lerner Wren's division, and then we'll see how we go from there. All right? Good luck, Ms. Parker. Stacy Stein.
I've been informed she bonded.
All right. I find probable cause. Lariah Ballantyne.
Bonded.
All right. I find probable cause. Ballantyne.
No prior, Your Honor.
Oh, is she? I'm sorry. Is Miss? I believe Miss. Did she? Has her bond been posted? Okay. Okay. Miss Ballantyne. Good afternoon.
Good afternoon.
For the record, Miss Ballantyne, you are before the court on count 1, touch or strike battery. Count 2 is a misdemeanor capias for a temporary tag violation. I find probable cause, and I have been advised that your bond has been posted.
Your Honor,
Yes.
I don't know if there's any backstory or history here, so just an abundance of caution, I'd ask for an order of no victim contact.
All right. I have no issue with that. Miss Ballantyne, there's going to be a no victim contact order. I don't know if you know the particular individual that was involved in this or not, but whether you do or do not know her, there's going to be a no victim contact order. That means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, I understand.
Okay. All right. Thank you very much.
Good luck, Miss Ballantyne.
Alicia Armidio.
North Broward,
Thank you.
with an eye toward resolving this matter if possible.
All right. Good afternoon, Ms. Armidio.
Good afternoon.
You're before the court this afternoon on 2 misdemeanor capiases. These are municipal ordinance violations, both related to alcohol beverage violations. I find probable cause, and I realize that these are MOs, but Mr. Linder, are you able to tell me if she has any priors?
Check, Your Honor.
Thank you.
It's like a couple prior DUIs, a violation of county ordinance.
Are they recent?
I'm sorry?
Are they recent?
No, not that recent. She went, a few years ago, she went through drug court on a possession of PvP. I don't see anything that should cause a court concern.
All right, Ms. Armidio, if you would like to resolve this case today, then the offer would be an adjudication of guilt with time served.
Okay, yes, please.
Okay, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. And Ms. Armidio, do you understand everything that we discussed so far today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by accepting a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And Ms. Armadio, what plea do you wish to enter, guilty or no contest?
No contest.
All right, thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence as to both of these charges will be an adjudication time served. Good luck
Thank
to
you.
you. Samantha Smith.
Also North Broward, Your Honor, and Ms. Smith would like to resolve this matter today.
Thank you. Good afternoon, Ms. Smith. Ms. Smith, you are before the court on a misdemeanor capias. This is a charge for petty theft. I find probable cause. And state, do you have an offer for her? Okay.
Withholding court costs. Yes.
Did you hear the offer, Ms. Smith?
Yes, I heard it.
Is that what you'd like to do today?
Yes, please.
All right, the judge has some questions for you, so listen carefully, please.
Okay.
All right, Ms. Smith, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
Thank you, Ms. Smith. I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication and court costs.
Thank you.
Good luck to you.
Thank you.
Good luck, Samantha.
Thank you.
Shermanda Phillips.
North Broward.
Thank you. Good afternoon, Ms. Phillips.
Good afternoon.
You are before the court this afternoon on count 1, grand theft auto, count 2, possession of cocaine, count 3, possession or use of drug paraphernalia, count 4 is for false identification given to law enforcement. I find probable cause, and I'll hear from the parties.
Judge, I'm going to be asking for pretrial release from Ms. Phillips. She has been a lifelong resident of South Florida. She's been living in the same location for the last 9 years. She lives with her mother. She does not believe her mother is going to be able to make the bond that's currently listed on the docket here. Also, she is currently has a high-risk pregnancy, and that is why she is not able to work right now. So she has medical issues that need to be dealt with, as well as her legal problems. So I'd ask the court to consider releasing her to pretrial release.
State.
She's out on bond right now for criminal use of personal identification information, identity theft, and possession of drug paraphernalia.
There's no need for you to say anything, Ms. Phillips.
Which,
Okay.
honestly, and I've got to say, you know, I would say it's a high-risk pregnancy, considering there's allegations here she's in possession of cocaine.
Have other priors?
2015, resisting without violence, unlawful use of false name ID and trespass. 2014, grand theft auto with the violation of probation.
Do you have any failures to appear?
Oh, I'm looking, I can tell you, Your Honor, as far as, ability to post bond, in the last 5 months, she's posted a total of $8,600 worth of bonds.
I don't think there's a lot more forthcoming as far as money to post bond is concerned at this point, Judge.
Answer the court's question, yes. She had a 2014 grand theft auto. She ended up having a capias issued for failure to appear, was arrested in 2017. Another capias on a battery in 2015. She also had her bond surrendered on a grand theft auto at that time. Another capias on a grand theft auto and battery.
I'm going to leave the standard bonds in place at this time. Job Tasman Rose Ramirez.
I think she's in the main jail, Judge.
All right. Good afternoon, Mr. Ramirez.
Hello.
You're before the court on a traffic capias. This is a charge for driving with a suspended license. I find probable cause. I hear from the parties.
Judge, on this 2015 offense, he wants to resolve, he wants to know if the state has a plea offer for him.
Yeah, I don't think that's a problem. Just if I could have one moment.
Okay.
Looks like this would be the second in his lifetime and first within a new 5-year period. State's offered to be a withhold court cost.
Wishes to accept the state's offer?
All right, Mr. Romero, did you have a discussion with him about the issues that come into play when you have more than one?
I did, on both issues, I did speak to him, Judge.
Okay.
Yes, ma'am.
All right. Okay, Mr. Ramirez, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Ramirez, do you understand everything that's been discussed here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, I do understand that.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
Okay, and what plea do you wish to enter, guilty or no contest?
No contest.
Thank you, Mr. Ramirez. I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Good luck to you. Kamar Jones.
I've been informed he bonded.
All right, if I'm probable cause. Alvaro Flores Restrepo.
Mr. Flores Restrepo. He's approaching, Judge.
Thank you. Good afternoon, Mr. Flores Restrepo. You're before the court on count 1, DUI, alcohol or drugs, first offense. Count 2, DUI with a blood alcohol level greater than .15. Count 3, driving in the wrong lane or side of the road. That is a traffic citation that is not for magistrate. I find probable cause, and I'll hear from the parties.
Judge, at this time, nothing damage on Mr. Flores' behalf. I'm going to be contacting his mother to post his monetary bond.
All right. In light of that, I'll leave the standard bonds in place. Thank you. Diallo Robinson.
Mr. Robinson, come on up, please.
Good afternoon, Mr. Robinson.
Good afternoon.
You're before the court on 1 count of loitering or prowling. I find probable cause, and I'll hear from the parties.
Judge, my understanding is Mr. Robinson has a clean record. He's 18 years old, been here his whole life. He's right now going to HD Perry. He's enrolled in the program trying to obtain his GED. He lives in West Park with his grandmother. Considering this is a second-degree misdemeanor, I'm asking if the court would consider an ROR on Mr. Robinson's behalf.
Your Honor, if I could just have one moment, I just want to see if he has any juvenile history. I'm not objecting to a non-monetary release. It really just comes down to whether I'd be recommending pretrial or just outright ROR. Your Honor, I have no objection. One moment, Judge. Yeah. I have no objection to an ROR. I would ask for no return to the instant location.
Is there a specific location?
Yes. 4400 Hillcrest Drive in Hollywood.
All right. Okay. Mr. Robinson, I'm going to ROR you, so you'll be released today. Please understand there will be a no return order in place. That means you are not to return to the location that's been discussed. Additionally, though you are going to be released today, please understand that this is not necessarily the end of the case. So it will be your responsibility to remain in contact with your attorney as well as the clerk's office to know any future court dates that you need to be present for. Do you understand that?
Yes.
Okay,
Those
thank
are
you.
those instructions. Read it. It has the phone number of our office and the clerk's office. Okay.
Johnny Caesar.
Caesar, come on up, please.
Good afternoon, Mr. Caesar. Mr. Caesar, you're before the court this afternoon on counts 1, 2, and 3 are each felony violations of pretrial. Those have no bond holds that are not for magistrate. Count 4 is a traffic capias. I find probable cause. In light of the no bond holds and the fact that you have a hearing before your division judge tomorrow morning, I'm going to leave the standard bond in place on count 4 at this time. Thank you. Tayon Sharp.
Please approach the judge.
Thank you. Good afternoon, Mr. Sharp.
Good afternoon.
Mr. Sharp, you are before the court this afternoon on 1 count for failing to redeliver leased property $300 or more. Find probable cause. I'll hear from the parties.
Judge, right now, Mr. Sharp advised me he's not going to be able to help post a monetary bond. He lives in Oakland Park with his sister. He's 39 years old, been here his whole entire life. I believe this is a rental car from Hertz, or he was in contact with the Hertz company, but he's going to be coming back to court, Judge, to face out these allegations. He has prior contact with the criminal justice system, but I believe it's been about 10 or 15 years, so we're asking for the court to consider releasing him on pretrial release.
State.
Your Honor, I have no objection to release the pretrial.
All right, very well, Mr. Sharp, you're going to be released to pretrial. I'm going to ROR you on this count. Your attorney is giving you some information there. Please understand that you need to report to pretrial within 24 hours of your release. If you fail to report as instructed, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, thank you very much. Okay, next is going to be Jerry Decius. His private attorney is here.
Michael Weinstein, I represent
Good
Mr. Decius. How are you?
Good afternoon, Mr. Weinstein. I'm good. How are you this afternoon?
Rushing, because my last client was a half hour late to Judge Bailey, but other than that, I'm
Oh,
good.
you should have been here this morning. My goodness, we were rushing all morning. All right, do we know where Mr. Decius is?
Paul Ryan, Your Honor.
Thank you. Good afternoon, Mr. Decius.
Good afternoon.
Mr.
Sorry, Judge, go ahead.
That's all right. Mr. Decius, so that you understand, you are here on 2 change of charge counts. And state, I just want to make sure that I have these correct. Count 1 was originally robbery with a weapon. It has been changed to robbery by sudden snatching without a weapon or firearm. Count 2 has been changed from aggravated battery to aggravated battery with a deadly weapon. Is that correct?
That is correct, Judge.
All right. And Mr. Weinstein, what did you want to tell me?
Judge, just to make my appearance, Michael Weinstein, I'm here on behalf of Mr. Decius. Hi, Jerry, how are you?
Good.
Good. Secondly, the state and I worked in cooperation. We do have an agreement. The state has offered to cut the bond in half for the aggravated battery to $2,500. Of the robbery that was downfiled to a $2,500, and that the trafficking has already been reduced down to $1,000 because that's now a possession. And Eric, what the last was?
The aggravated battery, Your Honor, it's really a lateral change. It's a technicality. Judge Powell originally set the bond at $5,000. Was just going to be seeking to just keep that in place.
Okay, so it'll be 2,500 on count 1 and 5,000 on count 2?
And there's already been a no contact order issued attached to the case, so that doesn't have to be reissued.
Okay, I see that. All right, based on the agreement of the parties, the bond on count 1 will be set at $2,500. The bond on count 2 will be set at $5,000. The no victim contact order that was originally in place will remain. All right.
Judge, if I just have, and if you can indulge me.
Yes.
Jerry, I will contact Tiara and let her know that the bonds are now available to be posted, okay?
All right.
Thank you.
All right.
What's that? No, what is it? Of course.
Okay. Thank you, Mr. Weinstein.
Thank you. Nice meeting you.
Joseph Jordan.
Judge, I'm in advisory bond.
All right. I find probable cause. Samuel Lee.
He's approaching, Judge.
Thank you. Good afternoon, Mr. Lee. Mr. Lee, you are before the court this afternoon on counts 1 and 2 are each a felony capias. Those have no bond holds that are not for magistrate. Counts 3 and 4 are each misdemeanor capiases related to municipal ordinance violations. I find probable cause, and you will have a hearing before your division judge tomorrow morning. Thank you. Arshad Hossein.
I've been advisory bond, Judge.
All right, I find probable cause. Marvin Perez.
I've been advisory bond.
All right, I find probable cause.
Mr. McLeod.
Marion Christopher McLeod.
He's approaching, Judge.
Thank you. Good afternoon, Mr. McLeod.
Good afternoon.
You're before the court on one count of robbery, no firearm or weapon. I find probable cause, and I'll hear from the parties.
Do you, Your Honor, if I could have a moment, if Mr. Romero wants to go first, that I don't mind.
Judge, Mr. McLeod's not gonna be in a position post a very high bond. He's actually gonna be relying on his sister to post it. He's 38, been here his whole entire life here in South Florida. He's self-employed, he's a handyman. From what he advised me, he doesn't make very much at all. He lives in Fort Lauderdale with his sister. His sister is the person that primarily pays all the bills. She works at American Express in customer service, making almost minimum wage. Judge, we're going to be asking for the court anywhere from about like $2,000 to $3,000 bond on his behalf. Now, Mr. McLeod does have priors, but I believe he's been out of custody now for about like 2 years. He's been clean since then. But we're going to be requesting about that, around $2,000 to $3,000 bond on Mr. McLeod's behalf, Judge.
Thank you.
And we're going to be requesting a phone order.
I'll sign the phone order.
Your Honor, I'm going to be requesting $10,000 bond, pretrial release of the GPS monitor, level 2, no victim contact. Mr. McLeod was released from state prison in February of 2018. That's from a 2-9 case where he was convicted of 2 counts of strong-arm robbery, 2 counts of battery on a law enforcement officer, 1 count of resisting with violence. He was sentenced to 10 years in state prison as a habitual offender. As far as Broward priors, 09, possession of cannabis with intent to sell, possession of cocaine, 06, DUI, 06, delivery of cocaine, 99, possession of cocaine, 98. Additionally, he has federal prior, 2000, conspiracy to possess crack cocaine with intent to sell or distribute, 39 months in federal prison. He ended up violating his supervised release in that case and was sentenced to an additional 7 months in federal prison. Gavi's concern being, after being sentenced to 10 years as a habitual offender, he's now before the court for the same offense that he was sentenced to prison for.
Set the bond at $5,000. If Mr. McLeod does post his bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be a no victim contact order in place. Mr. McLeod, I don't know if you know the alleged victim in this case or not, but whether you do or not, please understand that no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
All right, thank you. To our hearing docket. We'll do the misdemeanor docket first. Mr. Shea. late. You're right on time.
Judge, good morning. Good afternoon. I was stuck in the meeting with Judge Evans.
Well, you came in right on time, so you're fine.
Perfect. I
All
can
right.
see my buddy in the back there. He's one of my favorites.
Well, that's a good sign. Okay, so what I'll do is, I have the first 3 cases I have on the misdemeanor docket are all MOs, so if you're ready, then,
Is that the second look docket, Judge?
yes. Do you need a few minutes, or are you ready to go on?
No, let's go.
Okay, so the first one is Ashley Weimer.
She's in Paul Ryan, Judge. She'd like to resolve both of her cases today.
Is she on her,
Time served offer, Judge.
does she have 2 cases?
Yes, Judge, she's also on page 3.
Oh, I see her, okay.
She
She's
has
got
a
state
misdemeanor
case.
possession of drug paraphernalia.
All right. Says Ms. Weimer Schilling has a $100 bond on the the state case, is that correct?
Yeah, offer from the state on the paraphernalia would be an adjudication time, sir.
On her MO case,
It'll be a time served offer, Judge.
adjudication time served on both? Okay. All right, Ms. Weimer, so you had 2 cases before me today. One is the MO case for an alcohol beverage violation. The other is the state case for possession of drug paraphernalia. The offer on
Yes, ma'am.
both of those is an adjudication time served. Do you wish to accept that offer?
Yes, Your Honor.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. Ms. Weimer, do you understand everything that's been discussed here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorneys?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence on each case will be an adjudication time served.
Thank you, Your Honor.
Good luck to you, Ms. Weimer.
Take care of yourself, Ashley.
Thank you.
All right. Next on my list is David Odak.
He has a case on felony also.
Does he? I do see he has one on page 4 of the felony docket.
Judge, he has a felony offense as well as a municipal ordinance on the felony. It's possession of cocaine, $1,000 bond.
Okay, I do
He's
see
in no
that.
position to post it. He lives with his mother in Coconut Creek. No one's gonna be able to afford to post his bond. I know he's been here several times, so I believe he initially asked for pretrial. The court, I believe, was not inclined to give standard pretrial, so at this time now I'm asking for level 2, considering he has a place to stay, Judge.
Your Honor, really at this point, Mr. Odak really needs significant drug treatment. And even I don't know that a GPS monitor is gonna help with that. He just got out of custody 3 days before this arrest. He was arrested December 9th, taken into custody by Judge Levy because he violated his release conditions on 2 separate cases, one for theft, the other for trespass and inhaling chemical substances. He ended up resolving the case. He was sentenced to SAP and was released January 10th. And then within 3 days after going through a 30-day drug program in the jail, he's back before the court for possession of heroin. He has a lengthy history, but I think that in and of itself is cause for concern to not modify the bond at this time.
Judge, after the MO case, we'd rather it travel with the felonies so it doesn't affect him in any negative way. So on that, we'd ask that it just go to the division.
This time,
And I'm sorry, Judge, and if the court is so inclined, and I don't believe it's going to be, but if he is placed on pretrial release on the other matters, then we'd ask that this be an ROR. So if he's unable to post a monetary bond.
at this time, I'm going to leave the bond in place. Thank you. Rick Sherman, I'm sorry. Yes,
Mr.
they're
Sherman
gonna
is
say the same.
approaching, Judge.
Thank you.
He's looking forward to speaking to Mr. Shake.
All right. Thank you, Mr. Shate. All right. So, Mr. Sherman, Mr. Shate is here.
How you doing, Rick?
Yellow shirt, I see, I think. Good to see you again,
Good
Judge.
seeing you, bud.
All right.
In
Good
such
to see you.
short period of time.
I know, Mr. Sherman. All right. I got you for a second look today. So, let me see. He's got a $25 bond right now. So, Mr. Shate, what are we going to do with this?
Judge, it's a time
This is
served.
MO.
Go ahead, Rick Sherman.
Yeah, yeah, just an MO.
Yeah, it's a time served offer, Judge. I'm not sure if Mr. Sherman wants to accept it. Hopefully he does.
Mr. Sherman, it's an adjudication time served offer. Do you want to accept that?
I'm in the same position I was the last time, and I haven't had the opportunity to speak with Attorney Shate again this time, and I'd like to speak with him before,
Judge, if we,
because I would like to, if he doesn't want to speak with me, I'd like to, if he wants to represent me
Of course,
again
of
as
course.
a public defender.
definitely. Judge, is it possible, I've known Mr. Sherman for quite a while now. And is it possible, if this is the only thing holding him, that he's ROR'd, he keeps in constant contact with me, calls me, emails me, comes to court, so he's definitely responsible in that area. And I know he does like to talk about his case at length. So I don't want him to feel pressured, even if it's a time-served offer today. So, and Pompano Beach is very familiar with him as well, so.
So, Mr. Sherman, if I ROR you today, are you going to be coming back to court for your future hearings?
Yes, ma'am, I apologize that I missed the last time, which I was recently incarcerated for.
That's all right. Just know that if you're missing, then I'll know that I have Mr. Shate to blame, right?
That's, he will,
Yes,
I guarantee he will,
blame him
Judge.
Because,
I promise you he will.
just joking. Happy day 16.
All right. So, Mr. Sherman, I will grant Mr. Shate's request and ROR you today. Please know, I'm going to remind you, even though you're going to be released, this is not the end of the case. It's going to be your responsibility to keep in contact with Mr. Shate in the clerk's office so you know about future court dates that you have to be there for. You understand that?
I do understand, ma'am.
Okay. All right. Thank you, Mr. Sherman. Good luck.
Thank you, Judge. Thank you, Judge.
I'll talk to you later, Rick.
All right.
Yep, thank you.
Okay, so I think those are all the MOs. Let me just sign these orders and then we'll go over, we'll do the regular state cases that are on the misdemeanor docket. Okay, next up is Alberto Salas.
North Broward, I believe.
North Broward, Your Honor, and Mr. Salas would like to resolve this matter this morning.
All right,
North Broward, Your Honor.
thank you.
Hi.
Good afternoon, Mr. Salas. All right, so Mr. Salas has a $25 bond, is that correct? All right, State, do you have an offer for him?
One moment.
Take care, brother.
Your Honor, the offer from the state to resolve the matter would be an adjudication time served on both counts. No return to the target on University Drive in Davie.
Did you hear the offer, sir?
Yes, that's good.
All right, that's what you want to do?
Yes,
The
that's
judge
what I
has some questions for you, so pay attention, all right?
Okay.
All right, Mr. Salas, will you please raise your right hand?
Yes.
Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. And Mr. Salas, do you understand everything that's been discussed here so far today?
Yes, I understand.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of any drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, that's what I want to do.
Okay. Have you ever been treated for mental or emotional illness?
No.
Okay. And do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or have other immigration changes?
Yes.
And what plea do you wish to enter? Guilty or no contest?
The time served? Which one would that be?
You can plead no
First or second?
contest.
All right.
No contest.
Okay, it'll be a no contest plea. I accept your plea. I find that it's freely and voluntarily given, Mr. Salas, so that you understand your sentence on both charges will be an adjudication time served. Please understand there is also a no return order. That means you are not to return to the specific target that was mentioned. Do you understand that?
I understand. Yes, I understand.
All right, thank you very much. Good luck.
I get released today?
Yes, sir.
Thank you very much. Bye. Have a
Take
good
care.
day.
Dana Myers?
Hello. North Broward, Your Honor.
All right, thank you. Good afternoon, Ms. Myers.
Your Honor, this
Yes.
is a down file from possession of PVP to disorderly intoxication.
Okay.
I don't know if, Mr. Reedy, if based on your conversations, Ms. Myers wants to resolve the matter. If Ms. Myers wishes to resolve the matter, the offer would be adjudication time served.
Is that what you'd like to do, Ms. Myers? Adjudication
Yes,
time
sir.
served? All right.
Yes, sir.
Okay, listen carefully. The judge has some questions for you.
Okay, Ms.
Yes.
Ms. Myers, will you please raise your right hand?
Yes.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. Ms. Myers, do you understand everything that's been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak to your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you
Oh, for treated for emotional illness?
mental or emotional illness?
Oh, no.
Okay. No, you have not?
I have been for depression.
Okay.
Since the child.
Okay, well, is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. And do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
Ms. Myers, what plea do you wish to enter, guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. Ms. Myers, your sentence will be an adjudication time served. Good luck to you.
Thank you. Thank you.
You're welcome.
Good luck, Ms. Myers.
Thank you. So we will go over to the felony docket in just a moment. David Brown.
Talk to you.
Thank you. Is this a 30-day? Good afternoon, Mr. Brown.
Good afternoon, ma'am.
All right, so Mr. Brown's here for a 30-day hearing,
Now, the matter was downfiled as to a misdemeanor.
okay?
Let's see. filed to a misdemeanor trespass and DWLS. From what I can tell, this would not be a third. It's now case number 20-497 MM10A. If he wishes to resolve the case, the offer would be adjudication time served in both counts.
Did you hear the offer, Mr. Brown?
And Your Honor, real quick, Your Honor, you'd also have to prepare findings, have the clerk prepare findings for the misdemeanor case to do the resolution. 20497 MM10A.
Has he had any prior DWLSs, or is this the first one?
I can run an updated check, because he was first arrested in mid-November, and the driving transcript that was pulled at that time indicates no previous DWLSs.
All right, so Mr. Brown, if you want to resolve your case today, the state's offer to you will be an adjudication time served.
Yes, ma'am.
Do you want to accept that offer?
Yes, ma'am.
And Mr. Brown, so that you understand, the reason I was inquiring with the state about the driving with suspended license charges is because if you have 3 of those, 3 or more, then it's a mandatory 10 days in the county jail. Do you understand that?
Yes, ma'am.
Okay. All right, so Mr. Brown, if you wish to resolve your case, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. Yes, Mr.
Just so the court's aware, even if that was the case, Mr. Brown has well more than the 10 days accumulated already.
Okay. Well, I just want him to know for future is really
Of
what it
course,
came
yeah,
down to.
I just wanted to put that out there.
Okay. All right, so Mr. Brown, do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. And Mr. Brown, once again, your sentence will be an adjudication time served.
Oh, ma'am, that's
Yes.
on both my misdemeanors, right?
That's correct.
Okay, thank you.
Thank you. Good luck. That's correct. Correct. Next up will be Clinton Masses.
Paul Ryan, Your Honor.
Thank you. Good afternoon, Mr. Masses. All right, Mr. Masses is here on a 30-day hearing as well.
Yes, Your Honor, and information was filed yesterday.
All right, so Mr. Masses, the state has filed the charges against you, so your next step will be to go before your division judge for an arraignment hearing.
So what charge against me?
This is for aggravated battery causing bodily injury.
State filed a felony battery due to prior convictions.
Okay?
But also showing to change the charge though. I'm saying I need to know what's my bond for lesser charge.
What's the current bond?
See, if I don't like worry about it.
It's $4,000.
The current bond, Mr. Masses, is $4,000.
Yeah, that's the bond for it now, man. I'm saying I had aggravated battery, right?
Yes.
So they downgraded to battery, right? That's what they're showing, right?
The bond has been kept in place. The state would argue if Mr. Massis wants to seek a bond modification, his public defender can seek a motion in front of Judge Allspector, where the alleged victim can receive notice, and if he or she wants to be present pursuant to Marcy's law, then that can proceed.
So, Mr. Masses, for right now, the bond remains at $4,000. You'll be going before your division judge shortly for an arraignment hearing, and in the meantime, if you would like to discuss the bond issue with your public defender, then you'll have the opportunity to do that.
Okay, when would I be going in front of Al Spector? What day would I be going in front of Al Spector?
You should be getting a date relatively soon. I don't have her calendar in front of me, so I can't tell you, but it should be soon, and your attorney, I'm sure, will be reaching out to you shortly to talk about that. All right, thank you. Jonathan Raposo? Thank you. Do we have Jonathan Raposo at Maine? We'll find out. Mr. Romero, I can't hear you.
John Orso is here.
No, Raposo. Raposo.
I don't have Mr. Raposa listed on my paperwork, Judge. Is he on the second look or 30 day?
He's on the second look. I didn't have him when they sent me the original list for the second looks. He wasn't on it, but he's on my docket today.
Do you have his CIS number so they can look him up to see where he's at?
I don't know why he made, well, frankly, I don't know why he made the docket. He wasn't, you're right, he wasn't on the list.
Right, so how did he get on the docket?
And I suspect he wasn't scheduled because he's got an open aggravated fleeing and eluding in addition to this.
Why he's showing on the docket now then. But if that's the case, then we'll just take no action for today on his. Okay. All right, so we'll move on. The next one will be Stacy Groovers.
North Broward.
Thank you.
North Broward, Your Honor.
All right. Hi, Ms. Groovers.
Hello, Your Honor.
All right, so Ms. Groover's here for a second look.
Yeah, she ended up having her, because there were medical resets, she ended up having her first appearance yesterday. It was in the morning, I think it was afternoon. Yeah.
I remember it was yesterday.
Your Honor, just to rehash, Ms. Groover, she's been through a lot. She, through this division a lot. Her last release from jail was June 15th of 2019. That was on a violation of a possession of fentanyl. She was sentenced to 180 days in county jail on April 17th. Before that, she was arrested 2018. So a warrant for violating pretrial. And that was based on she never even, upon her release, she never even showed up to pretrial.
I didn't understand that I was that I was supposed to. That was my fault, yes, ma'am. Your Honor.
Then she failed to appear in court, and she got, a capias was issued, so she got picked up on the capias and the pretrial revocation. In late August of 28, there was a drug paraphernalia in 2018, sorry. Trespass 2018. Another trespass in 2017. Capias arrest in 2017 on a theft. Another capias arrest in 2015 on a theft. Capias arrest in 2014 on a 2013 case. EOP in 2013 on a possession of opium. Violation of probation arrest in 2013 on a possession of oxycodone and cocaine. Another capias on a theft in 2012. Capias on a municipal ordinance in 2012. Capias on a traffic matter 2011. 2007 possession of heroin and cocaine. It just goes on from there, Judge.
Just she can't make a $3,100 bond, Judge, I can tell you that. I don't know that she can make any monetary bond at all, quite frankly. I mean, the only thing I could ask for possibly is pretrial release.
Has she ever done the SAP program?
I'm sorry, Judge?
I just asked if she's ever done SAP, just based on her priors. I was curious.
I didn't ask her. Stacy, have you ever gone through the SAP program in the jail?
Yes.
When was the last time you went through that program?
I honestly don't remember, I believe the year before last. I'm not 100% positive.
You think you might benefit from going through that program again?
Possibly, I don't know. I was doing something with the MAP program.
It probably wouldn't hurt. What happened was, in 2018, Your Honor, she was court ordered by Judge Duffy into SAP and life skills. They had to remove her from the program because she refused to comply with the court order to enter the program.
You think you might have a different attitude about the program this time around?
Yeah, I might be getting bonded out tomorrow.
All right, well, even if the judge signs an order allowing you to enter the SAP program, if someone posts your bond, that wouldn't prevent you from being released.
Okay.
Do you want me to ask the court to sign an order authorizing you to get into the SAP program?
Yes.
You tell me.
Yes.
Okay.
Okay. All right, I'll sign the SAP order, and in the meantime, I'm going to leave the bonds in place as they are. All right. Thank you, Ms. Gruber. Good luck.
Thank you.
John Yerzua. Thank you. All right, good afternoon, Mr. Yerzua. He's here on his second look. I believe he's got a $1,000 bond in place.
Judge, we're gonna be asking for the court to consider releasing on pretrial. He lives in Fort Lauderdale with his uncle. He works for a place called Animal Aid, where he walks dogs. He just got that job about 4 months ago. So considering, this is not a violent offense, we're asking for him to be released on pretrial.
Your Honor, Mr. Urzua was just picked up 2 weeks ago for capiases on, one, leaving the scene of an accident, and then a DWLS with a drug paraphernalia. He was ROR, so there's driving offenses, there's drugs, and now he's arrested for both combined into one case. Driving unlawfully, and he's allegedly in possession of methamphetamine. That's just and he didn't show up in court. He's got another capias on a traffic matter from November of 2018. Got picked up in Broward on an out-of-county hold out of Collier County in 2016 for a violation of probation on a trespass. I don't have a lot of confidence about his future appearance in court.
I'm gonna leave the bond in place at this time. Tyrone Brooks.
He's approaching, Judge. Mr. Brooks, come on up, please.
Good afternoon, Mr. Brooks.
Good afternoon.
Mr. Brooks is here for a second look hearing as well.
Your Honor, may recall, Mr. Brooks was arrested on a fourth or subsequent DUI. You reviewed his driving. This involved an enhanced breath, a crash. You reviewed his driving record. That his driving privileges have been permanently disqualified, along with a 10-year suspension. You set the bond at $7,500 with other conditions. I think the bond and release conditions were appropriate then, considering it's a fourth DUI, and I think they're still appropriate now.
And Judge, he has, if my math's correct, about out a $10,000 bond or more. And Judge, he's not gonna be able to post any sort of monetary bond. He is on disability. He's 52 years, he has health issues. He lives in Coconut Creek with his sister and his daughter. My understanding, Judge, he's going through some health issues. We're gonna be asking for a medical screening, but second, Judge, we're gonna be asking for, considering this is his fourth, we're gonna be asking if the court would consider deleting the monetary aspect and just place him on level 1. That's gonna be basically complete house arrest lockdown. He's not gonna be able to go anywhere, so it's not like, he's not gonna be driving or anything like that. And I believe his last DUI was about 4 years ago. So I'm asking the court to consider releasing him under level 1 house arrest.
I think we should get the wording right. It's not that he's not gonna be permitted to. I mean, it's not that he's not gonna be able to, it's that he's not allowed to. Whether he does or doesn't is ultimately up to him. There's not gonna be anyone at his front door to stop him. And frankly, with his history, and considering this case involved a crash with I believe two other vehicles, or one other vehicle, and I mean, he was driving on a rim, I believe. I don't know that the court can have that much confidence that just left to his own devices, he will not get behind the wheel of a car.
I remember us discussing at the initial first appearance hearing the possibility, with regard to the GPS monitoring. The issue that I have in Mr. Brooks's case is that he has a very serious history as far as driving and his DUI history goes. And I mean, as we sit here today, from what I remember, I believe his license has been revoked or suspended at a minimum for some time now, but he's still been driving and allegedly drinking and driving. And the concern that I have is that if he is placed on the GPS monitor, while he, as Mr. Linder said, though he's not supposed to be leaving the house, he could potentially still do that, and that places both himself and other drivers on the road at risk. So at this time, if you need an order regarding the medical screening, then I will sign it. But with regard to the bonds and release conditions, I'm going to leave them in place at this time.
And Judge, will you sign that medical screening order?
Yes, I will. Okay, and I believe that was our last case for this afternoon. All right. I will sign the medical screening order. That's the end of our docket for today, so I'll see everybody back here tomorrow morning.